Start the recording. Oh, we have just started the recording now. So hey everyone, nice to see so many new faces and returning people. Today we're going to have a presentation by Miguel about limitation periods in private enforcement of competition law. Miguel also has recently published and had a 5-day intensive course about private enforcement, which is in YouTube. So especially for the students, if you're interested, it's highly welcome. So as we do always, the format will be 20 minutes of presentation by Miguel. And after that, we'll have time for Q&A. The way that we do the Q&A, that you just type your question in the chat, and please feel to do that during the presentation itself. And after that, we will give you the floor. So Miguel, thank you very much.
Okay, thank you. And I want to start by thanking Magali and ASCOLA UK for this invitation. It's really a pleasure to be able to see all of you and to talk to you. I tried to prepare something a little bit different than usual. So probably because I've been stuck at home and I'm a little bored, I've decided to tell you a story about Nightmare on Law Street. I'm an academic, but I'm also a practitioner, and I find that when we deal with the issue of limitation periods, it truly does become, or at least it has the definite potential to become very quickly nightmarish. So I would like to invite you to sit around the campfire with me right now and to listen to a little horror story. So the title is this: Limitation Periods and Antitrust Private Enforcement, Nightmare on Law Street. And before I get down to the actual story, here's just a little bit of a serious part. So the main sources on this are, of course, the Directive and the 2 cases of the court that discuss the issue specifically within the context of antitrust private enforcement. But of course, you have a lot of other case law which is relevant because it discusses limitation periods in other contexts, and you can extract lessons by analogy. And you also have a significant judgment of the EFTA court about this issue, which actually precedes Cogeco. And then I've included there some suggestions of works where you might find this further discussed, and the link to the course, which Or already mentioned, that I did on antitrust private enforcement. And you can see there on day 3, it's an entire day dedicated to limitation period with a very knowledgeable guest speaker, practitioner from the Netherlands, who goes into the details of these cases in his experience. So, I'm going to tell you a little story. This is sort of a movie that I've been seeing in bits and pieces here and there, and I'm going to try to put it together for all of you. It's a story about Mark, Tiffany, and Darnell, who are longtime friends, right? And they have been renting cabins in the woods every summer since they were 20 years old. And now they're 40, and they've been doing this. It's a tradition. They haven't even noticed how high the prices were all this time. The cabins were all located outside the town of Kaludberg, or I don't know if in the UK you'd say Kaludbra or something. The good people of Kaludberg are, of course, called colluders. So in 2015, Darnell heard this bizarre conspiracy nut on the radio saying that there was a killer clown who was often seen roaming the woods around Kaludberg. And for years, this vicious clown, basically what he's been doing is he's been going door to door, trying to get the righteous colluders to stop competing on the prices of their cabins. And therefore, this quickly became known as the killer clown cartel theory. At the time this, and I'm going to put up here so you can follow the story here. At the time, all of this sounded crazy. But then in 2016, the NCA, which is the National Clown Authority, the NCA published a press release saying that it had fined the mayor of Kaludberg for facilitating a cartel in cabin rentals while wearing a killer clown suit. And all of Kaludberg's cabin owners were also fined. It turns out that the NCA had been investigating this for 2 years. The non-confidential version of the decision was only published in early 2017. Now, the owner of Tiffany's cabin appealed the decision, but the owners of Marks and Darnell's cabins just settled and they didn't appeal. In 2018, the Anti-Clown Private Enforcement Act was adopted. And until then, you had a limitation period for infringements that was 3 years. And after this act, it became 5 years. And in fact, the act includes provisions that are remarkably similar to Articles 10 and Articles 22 of the EU Antitrust Damages Directive. So these are rules not only about the limitation period itself, but also about the temporal succession of laws. Mark, Tiffany, and Darnell only filed their claims in court last month, and they didn't do anything to interrupt the limitation period before then. So now we come to the present day, and hearings are taking place at a court in Kalundborg, and we're hearing arguments from the solicitors of the three main characters and the cartel members. And for some reason, probably because of COVID-19, all the solicitors and the judge are wearing hockey masks. So let's see, what are the arguments? The defendants first come up with the argument that under the Kalundborg Civil Code, the limitation period to challenge the lawfulness of rents starts to run on the day each rent was due. So that there is a special limitation period rule for this, and therefore that all the first rents that were being claimed, all the damages resulting from that had expired a long time ago. So here, what we would have to discuss is, does a special rule for limitation periods for a type of service or product take precedence over the special rule for the type of infringement? And this shows up a lot in many cases. Another question that you would have to discuss under this point is, in the case of continuous infringements, should the deadline only start when the infringement has ceased? And again, this is not going to be obvious in many of the legal orders. Some would say yes, some would say no. And we don't necessarily have an answer to this yet from the court, although I would say that through several paths, namely through the principle of effectiveness, you're going to end up having to say that in the case of a continuous infringement, as long as you didn't know before it was over, it's going to have to start at the moment it ended, or at least never before the moment it ended. The question is, what if you knew before? If you already knew before and it was a continuous infringement, does the clock not start running? And that's going to be a complicated issue. Second argument of the defendants. They would say that the deadline started to run in 2015, when the killer clown cartel theory was widely presented on the radio. And of course, the burden of proof is going to be on the defendants to show that there was already knowledge of the cartel at the time. But then we have to discuss, do they have to prove subjective knowledge? Or could they just prove that the three claimants were reasonably expected to know about the infringement? And in Spain, for example, some courts have said subjective knowledge is required. Now, if you hear somebody saying on the radio or even a news piece, okay, it might not be a conspiracy nut, it might be a more serious journalist, but if you hear them say that there is such a thing as a killer clown going around organizing a cartel, does this mean that you knew that there was a cartel? Right? And I'm going to take the opportunity now to already go over this idea of what does it mean to know? And if you look at the directive, at Article 10 of the directive, you're going to find that the legislator codified what he believes are the requisites that's probably under an effectiveness approach, the requisites that are required for somebody to be deemed as knowing about the infringement and the right to damages. And those are, you have to know about the behavior. I mean, sure, of course you have to know about the behavior, but you also have to know that the behavior constituted an infringement. In this case, an infringement of clown law. Why? Because if you do not know that it was an infringement, you don't know that you have a right to be compensated. Now, this might seem obvious, but in Portugal, for example, it's not. There is case law of the Supreme Court saying that You don't need legal knowledge, you just need factual knowledge. And this might work very well when you're talking about bricks falling on your car. It doesn't take a lawyer to understand that you have a right to be compensated by the person who dropped those bricks there. But when you're talking about competition infringements, it's far from that. And there's a reason why the court and AG Cocotte talked about the special complexity of competition infringement. That it's not a clear-cut conclusion from knowing certain facts until knowing that those facts actually support the existence of an infringement of the law. And there's a reason why we have specialized competition authorities looking into whether the requisites of lawfulness are met or not. It's not simple. The other thing is, oh, and by the way, here you have to distinguish the issue of secrecy from the issue of complexity. So, for example, in the UK, as far as I'm aware, there is a special rule that if people kept the infringement secret fraudulently, if they did their best to keep it secret, the limitation period doesn't start to run until it's publicly known. And that's not a rule in other member states. In many member states, it's not like that. So you have to distinguish the two issues, the issue of whether it was kept secret on purpose and whether that has an impact, and then whether or not the infringement itself is so complex that it requires diverging from the general rules of tort about when the limitation period starts to run. And that is, in my opinion, precisely why the directive says that you don't just need to know about the facts of the behavior, you need to know that it constituted an infringement of the law. Then you have to know that the infringement caused harm to you. And sure, okay, of course you have to know that it caused harm, otherwise you have no idea that you have a right to damages, but not that it caused a specific amount of harm. So it's not the precise quantum of the harm that you have to know, because you can discuss that in court. It can be highly uncertain. It might still be going on. It depends. So it's not the precise quantum, it's just that it caused harm. And finally, the directive also says that you need to know the identity of the infringers. And again, in some countries, namely in Portugal, that is not the case. You don't need to know the identity of the infringers in order for the limitation period to start running. Again, issues that will bring up the principle of effectiveness and the right of access to justice. A third argument that the defendants will say is that, okay, fine, even if they didn't know, they already knew enough that they should have moved. Can I say ass on this presentation? Can I say move their ass? All right, okay, it's allowed. They should have done something about it. They should have investigated. They should have asked access to documents. They should have, done disclosure procedures, whatever. And this was interestingly discussed in the EFTA court case. It's a very slippery slope, because if you say that you have an obligation to investigate and therefore the limitation period starts to run, you get into this bizarre situation where, if you're talking about mass damages cases that affected all consumers or affected thousands of companies all over Europe, you're basically saying that as soon as there is some kind of news about the possibility that there is an infringement, every single company has the obligation to start cases, to send out letters asking, this clearly is not going to work in our legal systems. It would be a nightmare for everyone involved, the defendants, the claimants, the courts, everyone. So I don't think that that anybody's going to say that we actually have an obligation to investigate just because we suspect that there is an infringement, if we're talking about a secret cartel. Or even if we're talking about other types of infringement, like abuses of dominance, unless it's something very clear-cut, unless it's something which public documents that you could easily have had access to just by asking an authority, and you didn't do it. Well, then if that's the case, sure, but not beyond that. Another argument that they're going to say is that the deadline started to run in 2016 when there was a press release. So the issue is, does a press release create knowledge of an infringement? Is it binding on the authority that issues it? No, it's not even meant to produce legally binding effects for anyone. It's just a press release. Does it create an obligation to investigate? Again, the same problem. Could you even investigate? You couldn't, because if you asked access to the decision, they would tell you, we don't have it ready yet. Wait, when we have the non-confidential version, we'll give it to you. So you don't really know anything from the press release, because the press release might be wrong. There's always a disclaimer saying, you know, this doesn't bind us in any way. The press release might describe the infringement wrong for all you know. So the press release, you can never rely on it to actually know that there was an infringement and what infringement. And you would not be able to do anything about finding out more information until the non-confidential version is made available. So another argument, they say, okay, fine, well then the starting date is the publication of the non-confidential version, which in this case was early 2017. Does that create knowledge of an infringement? Well, if you think about it, all you have, a lot of courts are saying yes. In Spain, for example, a lot of courts have said yes. And I find that absolutely astonishing. It's like we've completely forgotten about the rule of law. It's just the opinion of an authority. So a competition authority says that there was an infringement. So what? The infringers are the first ones to say that that really doesn't matter, because they have a right to go to court and prove that that was not true. Maybe the competition authority was wrong. Maybe they acted out of revenge against this mayor in the killer clown suit that is spoiling the great name of clowns, right? So we don't know if they abused their power. We don't know if the decision is true. Why should third parties assume that the decision is true? No, they should wait until the decision is final, either because it wasn't appealed or because it was confirmed by a court. And then, as a matter of law, in that legal order, we know that there was an infringement that can no longer be challenged, right? And then they can say, oh, okay, well, then there was an infringement. Before then, there is no reason for them to trust that there was an infringement. Think about the ridiculousness. You would have to go to court, and then the court would say, you file your claims action, and in the meantime, the public enforcement case comes back and says, no infringement. And you go, but I thought that there was an infringement. And so it would be bizarre to say that it starts on the date of a non-final, of the publication of a non-final decision. Then they would say that at least Mark and Darnell's claims would be time barred because the owners didn't appeal the decisions and more than 3 years had passed, right? So this would be another issue, that how can you distinguish, especially because of joint and several liability, do the limitation periods run autonomously, right? So that's a really big problem. And finally, they would invoke the absolute limitation period, which in some countries it's 10, others 15, others 20, others 30. They would say, well, here the absolute limitation period for the first years has run. And again, principle of effectiveness. In some cases, the absolute limitation period will have elapsed even before they knew about the infringement. Is that admissible? Probably not, right? But again, complicated discussion, which we still don't have enough information on. Now let's get to the claimants' lawyers, and I'm very much aware of time, which is quickly running out. The first thing the claimants' lawyers would say is that even if the deadline started to run in 2015, it was suspended by the investigation. Why? Well, basically because they would invoke not the directive, but the principle of effectiveness prior to the obligations deriving from the principle of effectiveness and the treaty already prior to the directive. And this is basically the discussion in Cogeco. Cogeco, unfortunately, is phrased in a way that left some doubts. The vast majority of doctrine interpreted it as meaning that there has to be an automatic suspension when there is an investigation. But the case came back to Portugal, and the first instance court didn't interpret it like that. And it said that the action was time barred, and now an appeal is pending. In fact, the Portuguese court said, yes, the ECJ did say that Portuguese law violated EU law, but they misinterpreted Portuguese law. There's actually no problem. And so decreed the action to be time barred. So the automatic suspension still needs to be, I think that it is the conclusion. I think just like the directive said, the court will eventually clarify that there should be an automatic suspension in these cases. But there are more complicated issues to this discussion. What if the law allowed you to suspend or interrupt the limitation period? What if the way that you had to do that, to interrupt it, was too costly or too complicated? What if there was legal uncertainty and you had to, for example, give a very high degree of precision on what the infringement was and you weren't able to do that at the time? And then when is this suspension lifted, right? Is it when the public enforcement procedure comes to an end, or is it a year after, like the directive says? Under the principle of effectiveness before, maybe you can't, maybe it's too much to say a year after. I don't know. Second argument, they would say that the limitation period only started to run the earliest when the non-confidential version of the decision was published, for the reasons that we've already discussed. You also have to look into the details of the infringement, because often, even from the press release, you don't know enough details to know exactly what the scope was and whether you were affected. By the way, sometimes you don't know from the decision itself. I have a case now where even from the decision itself, you have no idea who was affected by it because of the way it was drafted. Then they would say that the limitation period can start to run before the decision is final. Again, we've already discussed this issue. They would add that the new rules applied, came into force when the old deadline had not yet expired. And I'll ask our moderators for just a couple more minutes tolerance, please. The new rules came into force, and here you have several discussions. You have the problem that in principle there are no zombie actions, right? So if the thing was time barred before, then it's gone forever. But if it hadn't been time barred before, in principle, I would say the new deadline comes into force and you have an extension of the deadline. So it moves from 3 to 5 years, and they can invoke the 5 years deadline. But of course, this is connected to the discussion of whether these limitation period rules are substantive or procedural. And we have a lot of case law hesitations on this in the general case law. We have the Tarico trauma on this. You have Cocotte saying that they were substantive. Of course, she's coming from a German legal order where they are substantive, without actually providing justification for this from the EU case law. You have Cogeco in the court not really clarifying this, but at the same time, they seem to suggest that they were procedural because they said that the member states were free to choose if the new procedural provisions applied to actions filed between that period. So they seem to be talking about limitation as being procedural. They also talked about them as being rules concerning the exercise of the rights. But I don't think in the end it matters so much. I think even if it's substantive, you're still going to end up in the same result, which is substantive only means that you can't prohibit retroactive effect, but you still have to clarify what retroactive effect means. And I think that retroactivity in the case of limitation period should not be assessed by reference to the time of the infringement, but it should be reassessed by the time the action was filed. I really don't see what legitimate interest we would be protecting by using the time of the infringement as the relevant moment. What are we saying, that you wouldn't have done that infringement if you knew that the limitation period was longer? I don't get the argument. Why was that relevant at the time? Why would we need to protect retroactivity? Of course, this is not an issue which is free for the member states to decide. It might be substantive, it might be procedural, but ultimately it's up to the court to interpret the directive. Sure, okay, fine. But then the transpositions might say something different. And here I call your attention to the fact that there is a huge problem. Several member states interpreted these provisions differently. You have one group of France, Germany, Lithuania, which say basically what I'm saying, that it wasn't a zombie action, the deadline gets extended, it's the new deadline that starts applying. And then you have other countries like the Ireland and UK, which were incredibly restrictive and say, no, you apply the old one and that's it. And there is it's absolutely impossible to apply the new deadline. And finally, you just mentioned that you also have to consider the obligation to interpret national law in accordance to the directive. So even if you have a solution in the national law which seems to come, might be interpreted as going against a directive, if you can interpret it in a way that still achieves the result meant by the directive, obviously you have to. And you always have the option of suing the state afterwards. If you couldn't, because of the way that the transposition was done, you couldn't go to court. You can just turn around and sue the state afterwards, but good luck proving causality in that suit. And finally, they would also say, oh, by the way, this is not tort. This is contractual or unjust enrichment. In countries like Portugal, you have 20 years. You know, we had a direct contractual relation, and so we're going to apply the 20-year deadline, not the 3 years deadline. Everybody assumes that this is tort, but under the laws of many member states, that's not obvious at all. And finally, never forget that all of these discussions are rooted not just in the principle of effectiveness, but also in a fundamental right of access to justice. And we often forget that this is a fundamental right issue, that it can go to the ECHR, for example, and it's also a constitutional law problem in many member states. And two final plot twists. One is that what if the cartel had never ended, right? And we're having the sequel now. Well, then it's up to the plaintiffs to prove that, it's up to the claimants to prove that, and good luck proving that a secret cartel is still going on, right? So there they have a standalone action. And the second plot twist is, what if Mark knew? If Mark knew about this, maybe because, you know, back in 2013, the mayor was sick and he asked Mark, who was a buddy, hey, you put on the clown suit and do the rounds this time. That's up to them to prove it, and they can prove it. And of course, if you have subjective knowledge proven in court, then the limitation period would have to start then. And that's it. Thank you, and sorry for the extra 5 minutes. I apologize.
Thank you very much, Miguel. It was a very entertaining presentation. I feel always it's difficult to teach private enforcement in classes since it feels so procedural. So I think this is a great way to go about it. We already have a few questions, so we can start with Marco. But also for the rest of us, if you have any questions that you want to ask, please put it in the Q&A and you will get the floor. So Marcus, do you want to go first?
Yep, thank you. Well, Miguel, thank you very much for a very exciting presentation. And of course, it requires having read perhaps the Cogeco at least case first to fully grasp a part at least of what you were saying. But this was, this was very exciting. My question has to do with Directive 104 generally. I mean, I think that after Cogeco, we were wondering whether the directive had got it right or not. Maybe it wasn't complete enough. Maybe it's contradictory, not only in how it devises, the time limits, but also how the directive itself limits its effects over time. There was, it was very murky. But even leaving aside Cogeco, there's, we also have Skanska, of course, in which, the court said, well, the commission was saying the directive says that. And the court said, well, I'm not impressed, the directive does not apply. And I don't even agree that it says that. So, the directive technically is very poorly written. And that coincides with a huge drive of the Court of Justice reading the principle of effectiveness in a wholly different way, particularly on 101 and 102. I mean, what the court was doing up until now was combining the principle of effectiveness with the principle of equivalence and try to limit the application of national law and enforcement of EU law. But now they seem to have moved away from that and design a new principle of full effectiveness, which is not the old effectiveness, and which means that, within 101, there's a whole lot more than you would have guessed. And I wonder whether with this dynamic, we are going to end up discovering that Directive 104 is essentially useless. I'm still waiting for a case questioning the solution adopted in the directive to disconnect the case of the Court of Justice on flight error and on alchemy. I mean, because the solution in the directive is contradictory. Not necessarily for all of us entirely consistent with what the Court of Justice had said. And one last question I had, there's a very, very recent case, a Portuguese case in the field of state aid, in which the Court of Justice has also read quite aggressively, I would say, time limits. It's a side area, but it's also private enforcement of competition law. And, I was wondering if that, could help to confirm that the Court of Justice does not seem to be inclined to respect the deadlines the way some of us were accustomed to.
Mm-hmm. Well, thank you so much. A lot of really important questions to unpack here, which any of them would require a long time to discuss. But I'll start by your reference to the change in the way the court has dealt with this and the approach of full effectiveness. So as you know, this was an approach which was initially suggested by two Advocate Generals, Niels Waal and Cocotte, and the court took it on. And the way that I would explain that, and if you're interested in this, in the first or second day of that private enforcement course that is available on YouTube, I go into the details and all the case law that discusses that. But basically, it's that we're watching the birth of EU civil law, where the court is saying that if you have a right which is given to persons directly by the EU legal order, as is the case with right to damages for 101 or 102 infringements, then the requisites of those rights are governed directly by EU law. Who has the right to damages, who has to pay damages, how much, etc. Those are issues that are the conditions of the existence of the right and the extent of the right, and that's governed directly by EU law. That is a huge revolution. And I don't think that this is where Niels Waal talked about the full effectiveness approach. And I think that this is not going to be limited to antitrust. I think you're going to see this being extended to every other area of EU law where people are claiming rights that are given to them directly by the EU legal order. You then went from this, and then what's left for national law to regulate? The modalities for the exercise of those rights. So I'm not entirely convinced that that is the same thing as procedural law, procedural rules. I don't think that there's necessarily an overlap between that category and the ways that you exercise the right. Because, for example, we know that limitation period, the court includes in the ways that you exercise the right. It includes it in that category. So, and then you went from this issue and you said, well, does that mean that the directive will be useless? Will there be something left for the directive? I think that the directive has already been incredibly useful, and I have no doubts about that, because it has, not only for the publicity that has given to this issue, and it has kickstarted the private enforcement revolution, but also because it is serving as an inspiration for every national court, or almost every national court, and for the ECJ, to come up with the interpretations of EU law, even outside the scope of the directive. Right? It's very difficult to escape the argument that the legislator decided that this was necessary, that those solutions in the directive were necessary to ensure the effectiveness of EU law. And so if you invoke the principle of effectiveness, even before the directive, you're going to kind of have to end up arriving at the same solutions. Okay, maybe some little details you can't get to them, like maybe you can't get to a precise deadline of 5 years, but you can certainly get to when the clock starts to run, right? That those kinds of determinations are things that you can arrive at by the principle of effectiveness. And there's even an interesting constitutional debate there, which is EU constitutional debate, which is that if it can be argued that if the legislator adopted a solution which was not required to ensure the effectiveness of EU law, then that provision of the directive is invalid because it went beyond the scope of the competences of the legislator. So really complicated discussion there for the court to keep in mind. So no, I think that the directive will continue to, for the next years, in most cases, the directive will not be applicable in most issues, except in the procedural issues, and we've already seen that deciding what is a procedural issue is incredibly complicated. But certainly for limitation periods, for many years, we're still going to be discussing the old rules, and it's going to be this nightmare that we've seen. As for Vlijtiger, I'm happy that you mentioned it, because I definitely see a contradiction between the directive and that case law of the court. In fact, I'm handling a case now where it is exactly one of those situations where, in order to find out if you were injured by the practice, it seems like you might really need to have access to a leniency statement, because in nowhere else did they define who was affected. And that might be a case like that, which I don't know if it's going to be this one, but a case like that might be the thing to say, hey, this directive is invalid. This provision of the directive is invalid, because a directive cannot go against EU primary law as interpreted by the court. And so the directive cannot give absolute protection to a document after the court has already said that if there is no other way to determine if you have a right to damages, you need to have access to that document. So again, really complicated issue there. As for the Nelson and Tunj case, the state aid case, so I wasn't particularly surprised by that decision. So basically it's saying that the 10-year limitation period is in the relation between the state and the commission, but that the private person cannot invoke that they weren't warned in time because of it, that this is not, that they can't get away just, if the state does nothing, the private person can get away with that issue, right? Is this, am I remembering this correctly, Marcos?
Well, yes, but that had been already decided by the court a year earlier in Esti Pagar. So that was not the interesting bit. No, the interesting part is, when does the clock start running? You know, there's a very interesting discussion there in Nelson and Tunj.
I missed that specific discussion, and I'll have to get back to it. Okay. Any?
Thank you. I have a follow-on. One point that you said. So you mentioned that you think the directive was very effective in kickstarting the private enforcement revolution. Do you actually see a revolution in practice in the last 7 years?
7? No. But in the last 2 years, absolutely.
In what way?
It's just, so if you're a competition law practitioner, until about 2 years ago, it was absolutely exceptional for you to have a private enforcement case, for you to even worry about private enforcement. Today, if you're a competition law practitioner, it doesn't matter if you're on the claimant's or on the defendant's side, you're going to always have in mind to private enforcement. If you're representing infringers and you're negotiating decisions with the competition authorities, you're not worried about the fine anymore. You're worried about the content of the decision, and that's what you're negotiating. Making the decision as abstract and opaque as possible, so that you make it harder for people to go to court and ask for damages. And you know, the trucks cartel was just massive. It shows that you have over 10,000 claims all over Europe. In Spain alone, I know can tell us about that, I'm sure. In Spain alone, there are at least 5,000 actions that we know of, probably more. And it's going to also force us to rethink the organization of the judicial system to handle such cases.
But for now, I mean, if I understand it, it's still in the stage, so it will be litigation risk. But in terms of damages paid, that's still.
Oh, well, we've just started. It's too early, but you've seen a lot of damages decisions in Germany, in Spain, in the Netherlands. You have already a lot of such cases. I have no doubt that you are going to have. I understand why you're saying that, because we didn't have a lot of decisions on damages before. Mm-hmm. That's going to change, and I guess the best thing I can tell you to show you my confidence that this will change is that I opened a year ago. Not even I opened a law firm specializing on representing plaintiffs. So I definitely have a stake of interest in.
Thank you, Magali. You had a question.
Yeah, so just as an aside, I like that you pointed out the commission decision is not the law, not until the time to review has passed, because although that is obvious, it's not sufficiently emphasized, not even by the commission itself. But
definitely not by the commission.
No. So yeah, thanks for that. My question is actually quite a more general one, which is, have you noticed a trend in the interpretations by national courts of the directive, depending on how they stand in towards litigation towards a party? So have you noticed, though, more defendant favoring NCs interpreted that way, whereas more plaintiff favoring interpreted differently? Do you see any trends in that?
I think there's not enough empirical data to make any kind of assessment on that yet. The empirical data that I have, I think the most interesting collection is the one done by Professor Francisco Marcos in Spain around the drugs cartel, because there you have a large universe of cases already, and you know the outcomes. I just don't think that you can make any kind of determination on the even knowing the outcomes of the cases. I don't think you can draw a conclusion as to whether or not they were plaintiff friendly or defendant friendly. It's too difficult to make. I would say that especially if you're talking about follow-on claims, it's not so much the courts that are defendant-friendly, it's the law now. The law is defendant-friendly. So it's kind of hard to avoid the courts being defendant-friendly because they have to, the infringement is proven, they have to estimate the damages, even if the damages cannot be proven exactly. So there's not a lot that, however, you do see still tendencies, especially from non-specialist courts. You see tendency to come up with strange interpretations and throwing out cases based on things like disregarding the Skanska theory on the economic unit, limitation period interpretations, things like that. But if you look at this collection of cases by Francisco Marcos in Spain, it's the minority. The majority of cases are being successful, even when the court says, you did a poor job with this economist report, this is terrible, there's no quantification here, whatever, and they still get damages because the court said it was too difficult, let's estimate. So too early to say, but I think so far it's been possible to arrive at a successful outcome.
Barry has a similar question, maybe.
Barry.
Hi, yes, a great presentation, Miguel. So yeah, I sent a message to you privately, the mistake of chatting on Zoom. So first, as a kind of comment, I'm not sure if you're aware of the recent case in the UK, Granville Technologies, a few months ago. I mean, quite interesting for you. You would find it bizarre and ridiculous, but the court both confirmed that the directive doesn't apply. The time lag will be such that the directive might not apply for a while in these limitation periods cases. So it didn't apply, and the existing national limitation periods apply. And it was quite interesting. Basically, and I can't remember the precise details, but the basic point was, you're a business. There was stuff published in the in business journals. There was stuff published about an investigation by the Department of Justice. There's stuff published about the Commission undertaking an investigation. Hey, due diligence, you should know what you're doing. Don't expect to not know these things. So, I mean, so it's an interesting perspective. But also, the question is, could there be, even under national or even the new directive rules, could there be different standards in terms of the kind of reasonable diligence requirements for different types of claimants? Just a general point. One is a kind of comment, one's a kind of more abstract question.
Well, I'll start by the end. Yeah, I think that there can be different standards because this is governed by national law subject to the limits of the principle of effectiveness. And so that you can have, to a certain degree, different solutions of the national member states as long as they still protect the effectiveness of the right. Now, I don't know the details of the case that you were mentioning, but I find it incredibly difficult in the context of the complexity of competition law infringements to tell any company there was news about an investigation going on, you should have done the due diligence, because I mean that doesn't work for me. If it's a secret cartel, no, that's just ridiculous. If it's a secret cartel, they can't have access to this document. I know that the UK is all pro discovery, but are you really going to say every possible company that's been affected is going to have to do discovery and spend money on lawyers, and then the defendants are going to have to spend money on lawyers, and every single one of them is going to have to do their... That just doesn't make sense to me, not only because it would be economically inefficient and silly, but also because it just doesn't seem like it's a reasonable thing to demand of companies that just because somebody started an investigation, which might be completely it could be biased, it could be completely baseless, and they have to start doing a due diligence, or if they don't, later on, they're going to hear that the limitation period started to run. By the way, parenthesis, another problem there is the issue of complaints, that often companies who suspect an infringement will complain. Cogeco was a case like that, Naya Kistlink was a case like that. They'll complain precisely because they don't know whether the infringement actually existed or whether it meets all the legal requirements of an infringement of competition law, because in order to do that kind of assessment, you need to have access to confidential documentation. And they'll do the complaint, and national courts will have the tendency to say, as they have said twice in Portugal, as one court said in Norway, they're going to have the tendency to reply, well, you did a complaint, you knew about it. You know, and it's incredibly complicated because, you know, there is a reason why companies complain to competition authorities that have powers to go force companies to give them documents and do dawn raids and etc. If they knew everything that they need to know, why would they do a complaint? And even if they did, at the end of the day, go down the list of the requisites of the infringement. There's always going to be stuff that they will be incredibly doubtful at best, whether or not those things were met. Even if it's an abuse, the other guys can say, yeah, but it had a positive balance, or I deserved an exemption, or vouchers, or whatever. There's so much stuff. It's so uncertain that to tell people, yeah, you knew you had the right to damages, almost never will this be true. By the way, I would like to mention another case, Barry, which is the MasterCard decision of a few days ago, which was, I had no idea what that was. That's another horror story for me because I try to understand it, but it's just a bunch of English law being discussed there. And I was like, I had no idea what they're talking about. But if you're interested in limitation periods in the UK, in England and Wales, that decision is going to be very relevant.
Yeah. Thanks. Thank you.
Thank you. I'm looking at the time, so Miguel, can I ask you to move to the next slide, please? So as we normally do, we'll present the talk next week, but if we have still any questions, we can also have a few minutes of extra discussion after. And especially if you're a student or early career, please join us in the competition law and legislation after party. I just put the link in the chat. So it's an opportunity to meet other students from around the world who's interested in competition law, and also to ask questions you may feel uncomfortable to ask here, although you shouldn't, and so on. Next week, as you can see, we'll have Victoria and Magali having a debate, I think, in the end. Yeah, it'll be a fierce discussion and disagreement, might be violent, about market definition.
Vicky and I today had a discussion and we realized we agree on most things. So either I artificially pretend that I disagree with everything she says, or we're going to be like, oh yes, beautiful argument, I completely agree. So I'll try my best.
But luckily there's also an audience, right? So there's gonna, hopefully.
So be violence also among the audience, that would be great. So please do join us, and also probably you've seen that the timeline for the General ASCOLA conference was just published today, so it'll be a lot of discussion. Any other questions in the meantime? You can also feel free to just jump in if you want to ask Miguel anything.
Like I said, I think people are.
Oh, I see somebody. I think Alexandro raised his hand, or yeah. So yeah, go ahead.
Hi, Miguel. You were talking about like the beginning, so I didn't want to ask before because it's not quite related to your presentation, but you talked at the beginning about the birth of an EU civil law, and which is quite right now we're covering the right to damages. Do you have the feeling that it's going to be expanded to different remedies on the same basis, like the full effectiveness? You know, kind of expanding an EU civil law in that direction.
What do you mean to different remedies?
Like you would have, for example, because I'm trying to cope with that idea, but like you'd have different remedies recognized as EU remedies, and then you already
have that. You already have that as a matter of EU law.
We have
you have historical cases. Oh man, is it Master Foods? You have several historical cases from EU case law that say that if you have a right deriving from the EU legal order, you have a right to certain remedies, even if national law doesn't allow you the remedy. You know, the crazy English say that you can't have provisional measures against the Crown. That's ridiculous. Of course, you can have provisional measures against the Crown, at least if there's an EU right being invoked. So yeah, if that's what you mean, I think that you're going to see other damages, other remedies other than damages.
Okay. No, because I was just thinking like you do have EU remedies, but like as far as I know, probably I don't know, but you don't have them applied in the competition law field as EU remedies other than damages. That's what I was saying. You know, you'd have EU remedies applied in the context of competition law only, or not only, but also.
No, certainly you're going to. it follows from the case law that we already have that you have access to any remedy which you need in order to protect the effectiveness of your right. If that's an injunction, if that's a provisional measure, whatever that is, then yeah, of course, I think that's fairly clear already from the case law. Not specific for competition law, but from other areas.
Yeah. Thank you.
Other last comments? You know, are you trying to raise a hand? Then go ahead.
Can you hear me? Hey?
Kinda.
Okay.
It was actually better before, I think, without the earphones.
Yeah, I have the micro here.
It's okay, I know. We can kind of hear you.
Thank you, Miguel. Well, just a comment on the remedies, or the scope of remedies. Well, I agree, but it's in the case law, but always with the caveat that the remedies available according to national procedural laws. So you might not, it is my opinion in principle, you might not on the basis of effectiveness introduce a remedy that is not available in the particular member state. This is what I would just say on that.
Well, if you think about, I hope I'm not getting the name of the case wrong. Can somebody confirm if it was Master Foods that said what I was saying? No, not Master. Sorry, it wasn't Master. Of course, it wasn't Master Foods. Sorry, Master Foods about something completely different. What was the case that discussed the provisional measures in the UK against the Crown? Anyway, the court has said in a specific situation.
Factor time saga.
Factor time. Thank you. There you go. So the court has specifically said in a situation where the national law did not allow that kind of remedy, or at least it didn't allow that kind of remedy against that person, against the state. And the court has said, well, it doesn't matter. You have to create that remedy because it's necessary for effectiveness. My reading of the case law is that you can't argue that just because you don't allow this remedy at all, ever, in the legal order, then it's okay. You don't have to, because that would destroy effectiveness. I also think you have a fundamental right problem. You know, I'm always flabbergasted by why we need the EU court to step in these cases. Why don't the national courts just arrive at the same conclusion based on the right of access to justice and fundamental violation of a fundamental right? But there you go. We do need the court to step in, and if called to do so, I think it will.
Thank you. Thank you everyone for joining. Please join us next week. And for the students, if you want to join the after party, that will be great. Miguel, are you joining us for a few more minutes?
Sure.
Yeah, I will send you the link in email, so that would be easier. Bye everyone,
so much,
thank you.
Thank you so much. See you all next week. For the students, the link to the after party is in the chat box. Make sure to grab it, make sure to join us. In a few minutes, I will open that room and hopefully see you all there.
Bye.
Thank you, everyone.
I'll stay here for one more minute if somebody has a problem in the chat or...
I'm opening the room. Which means that eventually you will all be kicked out of here if you don't go to the student room.